my social media sites pick it up. So I try to talk a little bit in the beginning so that those that are signing on to those sites come right into the part where I'm beginning it so they don't miss anything. So apologize for the delay on this end. So good afternoon. Today is Monday, February 18, 2019. Happy President's Day. My name is Brad Micklin. I'm the managing member and lead attorney for the Micklin Law Group. We are a boutique law firm concentrated in men's and fathers' rights in divorce, custody, and family law issues, with offices in Nutley, Montclair, New Jersey. Today's video is being done, as I said, on the 19th of February, 2019 in New Jersey. My daily tip is intended to give you a very concise piece of advice on a topic that confronts many of my clients or many of my cases. But you need to remember that it's being done on a certain date and it's being done under what I know to be New Jersey law. So if you're watching it at any other time or any other state, you need to make sure that it applies or continues to apply to your case. So today's topic is about mediation, and I titled it The Biggest Problem Mediating a Case in New Jersey, but it's really the biggest problem that I see. I'm not saying that there's a problem with mediation. I don't want all the mediators who are out there to come and start giving me a hard time about this. I'm not a big fan of mediation for the reason about the state. Mediation is not done right by the majority of people who mediate. The majority of people who mediate arbitrate. And what I mean by that is instead of helping you come to a decision, they're trying to make the decision for you. Mediation is a process when the mediator, a third party, helps the two litigants try to come to their own agreement. Ask the one party how much do you want to pay in alimony, ask the other party how much they want to pay in alimony, and help them bridge that gap. That's very taxing in a divorce case. So the majority of people who mediate don't mediate it that way. They'll say, well, you're married this long, it's supposed to be this type of a duration, or you're generally going to pay this much, or we do it on this percentage. They will tell you what the law suggests it should be and try to get you to operate and agree inside of that. And that's not right. If you're a candidate to pay open duration alimony, a significant sum, but you're not willing to do so, or the other party's not looking for it, then it's not their job to tell you it should be any different. And most people will. And that's because mediating a divorce case is very taxing, and in many cases, maybe they're serving the interests of these people by moving the agreement more quickly, but that's not what their job is. If you hire somebody for a mediator, they're supposed to help you come to your own agreement, and the fact that they don't usually do that is the problem that I have with it. I'm going to be doing a how-to video probably this week on sort of this topic. I'm going to go through the different types of alternate dispute resolution processes like mediation, arbitration, and tell you what I think about them, what their purposes is, and when they serve a case and when they don't. So tune in for that. I'm not sure actually what day of the week it's going to be, but it probably is going to be in the next couple of days, usually around 4 o'clock. So if you have any information you want to see on that topic, message me before then, and I'll do what I can to include it. If this information was helpful, I'd appreciate it if you give a like to the video and share it to other people. You can subscribe to it and ask to get notifications when I go live so that you'll be able to catch more information, which I try to do at least once a day. And with that, I'm going to sign off and see you tomorrow.